Hello, my name is Hae-Sun Kim, advisor of Gangnam Labor Law Firm. Today with Labor Attorney Jung Bo-soo, we will cover another advisory case regarding the unfavorable change of working condition. So could you explain the content of the advisory service that we have provided recently, please?
Hello, how are you today? This is Bong Soo-jung, Korean labor attorney. Yes, just what you said is about some unfavorable change of working condition. So it's latest case is I have supported my client today. So one engineer who visited this labor law firm and explained she has worked for the one construction company. So in the beginning, actually she worked as a advisory engineer who worked from time to time because he was a senior engineer. So his service is advisory service, not going to work every day. So when he was hired, he has employment contract, he will receive 5 million won, and so that was a working condition. Then after 1 year, so this construction company's owner was changed. So they decided to reduce this engineer's salary from 5 million won to 30 million won. So then this employee was so angry, but he was afraid of losing his job. So he accepted. He didn't complain for reduced salary. So he thought he could take legal action later, then he could receive it. So then after for the first year he received 5 million won, but second and third year he could receive only 3 million won. So then recently he received special notice for his employment contract. So they suggest part-time employment contract. So he will receive 30 million won, same as before. However, there will be no severance pay. So he was very angry for this case. So he didn't in this case he quit his job and complained to the labor office. So he explained to labor inspector, company reduced his salary unilaterally without his the mutual agreement. So also company didn't pay severance pay. So that's why he claimed to the labor office. So for regarding this one, labor inspector told him he's entitled to 9 million on severance pay. However, some loss paid the wage for the last 2 years. I think the labor inspector told him he could not receive the loss paid amount of money because it's been almost 2 years. So for this case, he asked me about second opinion for this one. So I agreed with the labor inspector when employee worked there and also company changed the working condition. So in such a case, it is individual working condition. Then Article 28 of the Labor Standards Act. So following that article, company, the worker will take legal action within 30 months, but employee neglected the effective period of claim. So the labor inspector told him he should have claimed in the early stage, but it's been another 2 years, so you cannot claim that. So he had to accept that. However, severance pay is different, so company should pay severance pay. So labor inspector suggested this employee you should be satisfied with only receiving severance pay. So he asked about this case, and so I told him labor inspector judgment looks like acceptable. So if your working condition changes together with the other workers, I'm sure this is a change of the rules of employment. So in such a case, you can claim retroactively for lost paid amount of money. But this is an individual case, then it should be taken within 3 months from the unfairly reduced salary. So this is the only difference. So this is what I explained. So employee accepted to receiving. I mean, she accepted my settlement proposal, just receiving severance pay and giving up some legal claim for lost paid salary during the second, maybe listen to 2 years. Yeah.
I see. I think the employer who is the construction company, maybe they consider this employee's status is not a regular employee, but like a part-time employee, because he is has a national certificate to inspect some construction site or something like that. So, and also the other point is he has lost the timing of claiming about the unfair reduction of the salary. Yeah, so lost the timing. So eventually he can just request this 9 million won compensation. Is that what you have guided?
Yes, yeah. I think the workers should know when their salary is reduced, they should take the case through Labor Relations Commission within 3 months. So if the period is passed by, you cannot claim anymore. So it is very important part. Also, at the same time, also you should know some majority of workers' working condition have been changed. Then you can take legal action anytime within 30 years from the reduced salary. So individual reduction or collective reduction is very different. Yeah.
I see. So if there was a labor union and there were other staff or employee who had experienced the same condition, then the labor representative, employee representative can negotiate with the employer, but he was an individual person, so a very weak position to negotiate. Is that right?
Yes, that's right.
Yeah,
So
okay.
that's why labor inspector, the Labor Relations Commission is playing very important role to protect individual workers. However, collective relation, when employer revise the working condition collectively together in the rules of employment, then the workers can take legal action anytime without some effective period for this application. Yeah.
I see. Thank you very much for your consult.
Okay, thank you for your watching. Okay, bye bye.